Hello everyone, I trust all is well. This is my video presentation about our last case with Chevron. So I thought it would be good to give you a background about this case. So the petitioner was Chevron and the respondent was Natural Resource Defense Council, also known as NRDC. The lower court was the United States Court of Appeal for the District of Columbia. The case was argued in February 29, 1984, and was decided in June 25, 1984. The case arose as a challenge to an Environmental Protection Agency regulation. The specific regulation was the 1977 amendment to the Clean Air Act. What happened was that the EPA promulgated a rule interpreting the statutory term stationary source to include what the agency called um, bubble policy. I will try to elaborate on that with pictures so that you may be able to better understand the issue here. So ordinarily, under the Act, a permit was issued for new or modified major stationary source of air pollution only if the polluter met specific requirements imposed by the EPA. But under the regulations challenged in this case, EPA stated that an existing plant containing multiple pollution-emitting devices could install or modify a control equipment without permit only if the alteration would not increase the total emission from the plant. So I try to show the new pollution emitting device with the white and the modified one with the yellow. So as long as they are in the bubble here, they actually don't need any permits, and that's why the EPA was trying to expand. The NRDC challenged EPA's interpretation of the word source. Basically, they argued that the word referred to each individual pollution emitting device. In other words, plant source will still need to obtain a permit each time they create a new source of pollution or modify an existing source. The Court of Appeal, who at the time was the reviewing court, agreed with the NRDC. However, the case was escalated to the Supreme Court, and the Supreme Court reviewed the appellate court's decision and reversed it. The question here is to know whether a reviewing court have the right to impose its own construction on a specific statute when and if a statute administered by an agency is unclear or silent. Um, the answer to that is no. Another question is, which is kind of the same, is to know whether the EPA's bubble policy a reasonable policy choice for the agency to make, and the answer to that question is yes. I will try to elaborate on that in the next section. Right? Per Justice Paul Stevens, when a statute administered by an agency such as EPA is vague, silent, or ambiguous with respect to a specific matter, the court reviewing the case might not impose its own construction on the statute in question. Rather, the reviewing court should deliver its verdict after confronting two specific questions that I will explain in the analysis part in a second. When delivering the opinion of the court, Justice Stevens mentioned that the first thing a reviewing court should do when or if a status administered by an agency is silent or ambiguous is to consider whether the Congress directly addressed a specific issue. He stated in the article that if indeed the intent of Congress is clear, then that is the end of the matter. Secondly, as mentioned in the article, if the reviewing court find that the statute administered by an agency is unclear or silent or vague, then what the court need to do is considering whether the agency's answer is based on a permissible construction of the status. He mentioned that an agency's power extends to filling both implicit and explicit gaps that Congress left in a statute. If Congress leaves an explicit gap, then it is the responsibility of the agency to fill that gap by implementing regulations. Justice Stevens um, referred to that as a delegation of authority. He stated that a reviewing court must give effect to those regulations unless they are arbitrary, capricious, or manifestly contrary to the status. If, however, Congress implicitly left a gap, then the agency has the authority to fill the gap, and that the reviewing court, may not disturb or substitute its own construction of a statutory provision for a reasonable interpretation made by the administrator of an agency. And this whole doctrine, this whole principle is what's known as the Chevron deference, which I will talk about that later. As stated in the article, the Supreme Court agreed with the Court of Appeals on the fact that Congress did not have a specific intention on the applicability of the bubble concept in this case. However, the error of the Court of Appeals was to adopt a static judicial definition of the term stationary source, and it wasn't their place to do that. Therefore, based on the analysis provided earlier, the Supreme Court reversed the Court of Appeals decision. For me, there is no doubt that this particular case was wisely decided. As I mentioned before, with this ruling, the Supreme Court established the well-known and so-called Chevron doctrine. The same doctrine was used in our last briefcase, um, King versus Bowell. This case is one of the most influential and cited cases when it comes to administrative law in the US. That is why it is considered a landmark case. Now, today, whether it is considered a sound public policy is hard to answer, but at the time, though, there was an overarching rationale behind the Chevron doctrine. So, at the time, I believe it was a sound public policy. However, this doctrine has grown so much today, and there are so much debates and controversies around it, which is not good because so many people are trying to take advantage of it. That is it for my presentation. I hope I was able to make you understand it. Please feel free to leave a comment below or on Blackboard. Thank you so much.